Preventing sexual harassment in the workplace. What is sexual harassment? Harassment includes offensive behaviors, actions, or communications that are threatening, disturbing, persistent, and unlawful. It's a form of discrimination that occurs in the workplace and consists of vulgar or unwholesome language, profanity, signs, jokes, pranks, intimidation, demeaning, berating, or rude terms that are offensive to person and to others present, and physical actions or violence directed at an employee due to any protected characteristics. Protected characteristics include age, race, creed, color, national origin, sexual orientation, military status, sex, disability, marital status, domestic violence victim status, gender identity, and criminal history. What is sexual harassment? Unwelcome sexual advances, requests for sexual favors, other verbal or physical conduct of a sexual nature. It affects an individual's employment, unreasonably interferes with an individual's work performance, and creates an intimidating, hostile, or offensive work environment. Federal laws prohibiting sexual harassment and discrimination. Equal Employment Opportunity Commission, EEOC laws. Protect employees from discrimination, retaliation, and harassment in employment. Define sexual harassment as unwelcome sexual conduct made either explicitly or implicitly. EEOC's guidelines on sexual harassment. EEOC's guidelines define two kinds of sexual harassment. Quid pro quo harassment. Person in a position of authority makes advances towards a subordinate and promise a raise or promotion if the subordinate gives in to those advances. Hostile environmental harassment. Atmosphere of sexual comments or jokes creates an offensive or threatening work environment. There is no place for sexual harassment in the workplace. Everyone is protected from sexual harassment in workplace subject to applicable anti-discrimination laws. Everyone has the responsibility to refrain from engaging in unlawful harassment. Employers must protect their employees from each other and from harassment by residents and workplace visitors, address harassment committed by employees against non-employees, and any employee who engages in unlawful harassment of co-worker can be held personally liable for the harassment. Where can sexual harassment occur? It can occur whenever and wherever employees are fulfilling their work responsibilities, including in the field, at any employer-sponsored event, trainings, conference open to the public, and office parties. Harassing behavior that in any way affects the work environment is rightly the concern of management. Sexual harassment in the workplace. The victim as well as the harasser may be a man or a woman, including harassment of a person of the same gender. The victim does not have to be of the opposite sex. The harasser's conduct must be unwelcomed. Unwelcome sexual conduct in the workplace. The conduct or behavior of a person who engages in sexual harassment can be physical, verbal, or nonverbal. Sex stereotyping. Harassing a person because that person does not conform to gender stereotype as to appropriate looks, speech, personality, or lifestyle is sexual harassment. Response to sexual harassment is subjective. It is in the eye of the victim. What does not offend one may offend another. If it offends one person, it is considered harassment and/or discrimination. How can a victim respond to sexual harassment in the workplace? The victim should inform the harasser directly that the conduct is unwelcome and must stop. Never assume that management knows. Use any employer internal complaint mechanism or grievance system available to report unwelcome sexual conduct. Leadership responsibilities. Supervisors and managers are held to a high standard of behavior. This is because they are placed in a position of authority by the employer and must not abuse that authority. Their actions can create liability for the employer. They are required to report any harassment that is reported to them or that they observe. They are expected to model appropriate workplace behavior. Responding to reports of sexual harassment, managers and supervisors must notify HR immediately when issues or complaints arise, or if they observe incidents that could relate to sexual harassment. Reporting sexual harassment. Report all complaints of sexual misconduct per company policy to ensure impartial and prompt investigation. Mandatory reporting. Supervisors must report any harassment that they observe or know of, even if no one is subject to the harassment. Supervisors and managers will also be subjected to discipline for engaging in any retaliation. Responding to reports of sexual harassment, zero tolerance. Employees may not be disciplined, demoted, or terminated because they reported in good faith an incident of sexual misconduct, participated in an investigation of a sexual misconduct claim, and retaliation is prohibited. Protected activities. Any employee who has engaged in protective activities is protected by law from being retaliated against because of that protected activity. What is retaliation? Retaliation is any action taken to alter an employee's term and conditions of employment. Retaliation can be any such negative action taken by the employer against the employee that could have the effect of discouraging a reasonable worker from making a complaint about harassment or discrimination. What is not retaliation? In order to establish a claim of retaliation, an individual must be able to show that the adverse action was motivated by the protected activity. Preventing retaliation. To avoid retaliation, company personnel must provide training on retaliation to all employees, investigate immediately any claims of discrimination, take corrective action, and apply discipline where needed consistently. Investigating workplace sexual harassment. Major points to consider in an effective complaint investigation include timeliness, objectivity and credibility, and confidentiality. Investigation and corrective actions. All employers must investigate a report of harassment. An investigation of any complaint should be completed within a reasonable time frame. Addressing sexual harassment. For confirmed incident of sexual harassment, the company's response, at a minimum, includes the offender must be counseled, reprimanded by a supervisor. We prepare a written record of the offense. In addition to referral to counseling, withholding a promotion, reassignment, temporary suspension without pay, financial penalties, termination, false accusations are subject to disciplinary action. Preventing workplace sexual harassment. Prevention is the best tool to eliminate sexual harassment in the workplace. Basic premise: prevent workplace sexual harassment. Respect the rights, values, dignity, and culture of others. Conduct oneself in a professional manner. Refrain from making and or participating in any jokes, language, conversation, or physical action which others may find offensive. Even though a comment or joke is not intended to be malicious, it is the perception one develops from the joke or comment that others may consider offensive. New York City, private employer obligations to prevent sexual harassment. Private employers with 15 or more employees must conduct annual interactive sexual harassment training, post anti-harassment posters, extend the statute of limitations to file sexual harassment claims, and be subject to sexual harassment prohibitions as according to the New York City Human Resource Law. New York City Training Requirements. So all private New York City employees with 15 or more employees must conduct annual interactive training. The training is required after 90 days of initial hire, and training may be in person or through an online program. Sexual harassment training in New York City. Employees shall keep a record of all the trainings. Employees shall maintain such records for at least 3 years, and all employees in New York City must display a discrimination, sexual harassment rights, and responsibility poster designated by the Commission on Human Rights. Employees may utilize the complaint process available through the Commission Division of Human Rights and the EEOC. They're a website that you can find on the computer. Bystanders intervention. Bystander in the workplace can play an essential role in developing and maintaining a team-first mentality amongst coworkers. Active and properly trained bystanders can offer emotional support for victims of workplace sexual harassment. The EEOC has listed bystander intervention training. New York State information. A complaint alleging violation of human rights law may be filed either with Division of Human Rights or the Supreme Court. You can find this information on the computer. Reporting sexual harassment, either orally or in writing, contact the designated company representative, including the supervisor, the compliance officer, the compliance hotline, and that is available 24 hours, 7 days a week. Reports may be made to the hotline anonymously, or you can leave your name. Sexual harassment, discrimination, compliance management. Do the right thing. Be familiar and comply with your laws, rules, regulations, and company policies. Report any sexual harassment and or discrimination violations immediately and cooperate with any inquiry into the facts.